But that said, I mean, I was really looking forward to seeing a Coinbase order before we did this episode, and we haven't seen one yet, which makes me sad.
Yeah, I mean, look, you almost said definitively that we would see a Coinbase decision by now. And let me lay the groundworks, okay, before I have you respond, because I, almost sounded definitive, and now I got to call you out a little bit, right? So, on January 17th, Coinbase went into court with a very important meet with the SEC. And, why were they there? They were there to discuss the 12 coins that were listed as securities from the SEC and to discuss with the judge with whatever questions the judge had on why and the basis and the howie and why these coins listed as securities. And the judge, from the line of questioning that the judge gave, seemed to kind of be on Coinbase's side. And you can come in with what you think here, but from the way the judge asked his questions and pre-printed the conversation, and the SEC was kind of at some points flabbergasted on. This was a very, very important date because guess what? This January 17th, 2004 date leads to is a possible dismissal of the case or continuation of the case, which is what Coinbase is asking for is a complete dismissal. But when it comes to the judge itself, she seems to ask a lot of questions that this is my interpretation of my take. These questions put the SEC in a precarious position where they are the ones that kind of have to prove something, and that then either leads on to the discovery phase of things or puts us in a position where the burden is on the SEC for proof. And that's always the case. But give me your thoughts not only on the January 17th meeting on whether to dismiss the case, why we're waiting so long to hear what the judge's decision is, and then from this January 17th date, what could we be looking forward to? Are we looking at possibly going from hey, judge, give us a dismissal? We're going to discovery, and from discovery, is it possibly going to last as long as the Ripple case? With the possible remedies that we'll have in place once we get the evidence from this discovery phase.
Yeah, so I mean, it's my personal opinion that the way the judge was asking questions, she thinks half of the case should advance to discovery, and she thinks half of it should go out the door. I think particularly on the wallet part, I think she's saying she's going to come down and say that is not. We haven't sufficiently alleged that the Coinbase wallet is a securities offering, and I think that's going to be a fair decision just based on her questions. And the fact that she didn't spend too much time on it during the hearing, it seemed like she asked some questions, got confirmed her understanding on wallet, and put that aside. The ones that really took a long time were the issue of staking, right, through Coinbase, and whether the Coinbase's efforts are managerial or actually ministerial, right? So it's like, are you just the guy who plugs in the data and pushes the button? That's ministerial, or are you thinking? Are you making a decision based on a judgment of some kind? That's more managerial, right? And Coinbase's lawyers were arguing that it was a ministerial situation because that, under the test for securities laws, really gets them a lot of points in favor of saying that no, this is not a security because it's not the efforts of others, the managerial efforts of Coinbase that makes staking through their system valuable. I think what we're going to see is a decision that grants and in part and denies in part Coinbase's motion to dismiss. And so what happens when you get a 50-50 like that on a motion to dismiss? It actually kind of puts the choice in the plaintiff's hands. And so that's the SEC here in this scenario. And the SEC can decide to either amend their complaint and try again as to the parts that were dismissed. Because you do get, like, under the law, you get several chances to try again, unless you just are just, basically unless you're just dicking with the court, which is really rare. But so it's very likely that the SEC, even if all of it's denied, would have a chance, or even if all of it is granted, they would have a chance to file an amended complaint, try again, put more detailed facts in, and we would end up in very much a similar position where we are now, because after a first amended complaint, you know what our strategy always is? That's a new motion to dismiss. And so that is one possibility. If it goes the way I think it's going to go, which is a 50-50, a grant in part, deny in part, the SEC has to choose whether they want to proceed with the parts that weren't dismissed, or whether they want to file an amended complaint and try to get all of it back in. So if they do file an amended complaint, it'll be effectively as if Coinbase would have the opportunity to move to dismiss all of the things where it had won before, but not any of the things where it had lost before, because we're not going to redo those, just as a matter of the rules. And then the other alternative option, which I think is actually the least likely of them all, I really do think the middle option is what the court's going to end up landing on. But here, I think the other alternative is that the SEC wins entirely, and the motion to dismiss is denied in full. And in that case, Coinbase has to answer, and we do immediately move on to discovery. So it's my opinion that we're probably looking at several more months on the pleadings phase, which is, if you'll recall from the last time we did this, that's phase one of litigation. It's does your opening papers, is it good enough? Have you put enough pieces of fact on the board as allegations, not as evidence, but just as hearsay allegations? Have you put enough pieces on the board that we can play the game? And that, I think, is probably, we're going to end up with another motion to dismiss, and the SEC will likely file a First Amendment complaint, because I think they really want to get Coinbase on all of these issues. And so it's my opinion that that's what they'll do, is go for the First Amendment complaint route, and then we'll have another motion to dismiss. And you've seen how long this has taken. So we're looking at another 6 months maybe before we even get to discovery. And going to your question about whether we would have a discovery of a similar length of time with Ripple, I mean, it's hard to say, because discovery is not dictated by the court. It is dictated by the lawyers for each party, right? Like, I decide what I want to request from the other side. They decide what they want to request from me. And it's only where we heavily disagree that the court has to get involved. And just for context, the court is always pissed when you make them get involved in discovery disputes, because we're supposed to be civil. We're supposed to be, giving our evidence over that we're going to use to prove the case, and not hiding the ball. And the court, when it sees discovery disputes, sees it as hiding the ball. Now, Ripple had a ton of discovery disputes because the SEC wouldn't give over a lot of information that the Ripple attorneys viewed as very relevant. And so that is one aspect that compounded the Ripple discovery, such that the Coinbase one may be shorter. However, Ripple only involved one token. Coinbase involved 6 at least, right? Unless they decide to expand the issues. So that could mean a much more lengthy discovery process, with questions and responses directed at each and every one of the tokens involved. And if it gets contentious like Ripple did, which I don't see any reason why it wouldn't, given Coinbase's stance towards the SEC and what I've seen Paul Graywall tweeting, I have a feeling it's going to be a very arduous several years of discovery, to long past Gary Gensler's tenure at the SEC.
Yeah, I mean, that sounds rough, right? It sounds rough. And it's really good feedback from you, because as someone who was involved and watched the XRP Ripple case play out, I mean, we're in our 3rd year, and our discovery phase, lasted quite a bit of time, because we were willing to be fighters, right? On the John Deaton end, representing the XRP holders, and separately on the Ripple end, representing themselves. And so Coinbase looks like quite the fighter. So to get that perspective is interesting, and it looks like this might be, at least on discovery end, drawn out about 4 to 6 months at the minimum. But yeah, it looks like the SEC also is here to play the long end of the game. And so really good insight. I peeped you may have an additional thought.
Yeah, one thought you asked a bit. I'm not sure, maybe you didn't, but I want to address, like, why has it taken so long for the court to issue its ruling on this motion to dismiss? Honestly, it normally doesn't take very long. Normally, we get a ruling on a motion to dismiss within 2 weeks after a hearing in a normal case. Many that I've worked. Only one has ever gone like even close to this long, and it didn't go this long, which is why I had so much confidence that we would have a decision before this episode. But that said, what it says is that the court is honestly still thinking about it, because the court has no deadline by which they have to issue an order, unless it's like absent some very extreme circumstances that aren't yet present here. And so that tells me that what the court is probably having its clerks run down additional research, running down additional questions that she has after hearing the attorneys argue it out, and making sure that all of her ducks are in a row. Because remember what I mentioned before, judges have a KPI, and that is reversals. And so she wants to make sure that at the beginning of this case, at the outset, that she has all of her ducks in a row to the best that she can, and prevents any opportunity of a reversal of this order down the line, which is it would be that's the kind of thing that extends litigation for years and years if you have a reversal after trial of an early motion to dismiss. So I think that she's trying to really make sure she gets her ducks in a row and gives credence to all of the arguments from all of the parties. And selfishly, I'll throw in just my opinion that I think part of it is that she really wants to abandon the pleading standard, which is the pleading standard is that on a motion to dismiss, the court has to accept all factual allegations in the complaint as true. It's true because all we're deciding whether or not there's enough here to warrant going to discovery to see if it's true. So if we believe that it all is true, is that actually a claim? And she wanted to take the facts about staking as they were presented in the amicus briefs, and not as they were presented in the SEC's complaint. And I think she's trying to grapple with that, because I think she understands that the way the SEC presented the information in its complaint is not correct about staking specifically. But as the judge, technically it's not her job to make that decision yet. She's supposed to believe everything the SEC tells her at this point and what it says in the complaint. And I think maybe one thing that's taking a while is that she's really trying to see if there's any way that she can narrow the issues of this case and exclude staking at the front end by taking the facts as they were presented by the amici. Now, that said, I personally don't think she can. I think she is bound to that pleading standard. And as an attorney who practices sometimes in federal court, I would expect her to feel bound to that pleading standard. And so I selfishly believe that that's part of what she's grappling with.
Gotcha. So things are taking a little bit longer because yes, this it's not a normal occurrence, right? And so as you mentioned, judges care about their KPIs, their key performance indicators, and they want to make sure that they cross their T's and dot their I's. And that may be what's happening here, right? It happened a few times in a Ripple case. And I think even these judges are kind of seeing, holy crap, there's some major historical contacts with some of these cases, right? And so, right now with the Coinbase case, there's a delay in the normal average time. The next time that we have Stycksintern on, I mean, by that time, I would hope we have some sort of an additional update. But the
I'm not making
gems
any
that
promises.
he's not making any. He made promises last time. He's like, listen,
Learn my lesson.
learn my lesson for sure. But look, I faced that so many times in the Ripple SEC case, and I have faced that numerous times in tracking the XRP token itself and its price action. It gets in, becomes normal. But the real gem that I'm getting from this breakdown and analysis is that this is going to be a grueling battle, very similar to the Ripple case. The judges are very cognizant that these are really historical markers, especially in the US, right? And so they're going to do their due diligence. They're going to make sure they cover everything. But what it seems like after and as they do their due diligence is they're siding on the right side of history, and they are siding with blockchain and crypto. And so we'll continue to watch what's going on in the Coinbase end of things, but that just so perfectly